Experts say it could result in more firearms, concealed firearms, on the streets of many major cities. Kira?
Or licensed security officer shall possess a firearm.
Gun, we're outmanned, we're outstaffed. We do need responsible gun legislation.
That men and women in this country have the right to defend their own lives.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
That suspension does not apply to any private property.
Ban assault weapons, ban them again, do it now. Enough, do something.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Getting weapons, AR-15s, out of the hands of people who shouldn't have them.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
The Supreme Court recently rejected an emergency review of the New York concealed carry legislation and the limits it imposes on ammunition. Ruling of the Supreme Court on proper cause. The U.S. Supreme Court has ruled that New York's proper cause concealed carry statute, which requires that proper cause be proven before receiving a license to carry a handarm outside of one's house, is unconstitutional. The decision, which has been in effect since 1911, calls into question laws governing concealed carry permits in 8 other states and the District of Columbia that are comparable to those in New York, and constitutes the largest expansion of arm rights in more than 10 years.
That you said that all assault weapons should be banned. Is that a fair statement?
Under the new rule, firearm owners will be required to obtain special registration, surrender or destroy their brace.
The law, which has been in effect since 1911, was declared unconstitutional by the Supreme Court's 6 conservative judges. Justice Clarence Thomas, who wrote the majority judgment in the case, claimed that the New York Act violated the 14th Amendment of the Constitution, which ensures that everyone has a right to receive equal treatment under the law. The decision was taken a few weeks after mass slayings at a Uvalde, Texas elementary school and a Buffalo, New York grocery store revived national discussions about arm control. Democratic political figures swiftly denounced the choice, claiming it would endanger public safety. President Joe Biden advocated for common-sense arm laws to be implemented by governments to save their people and communities from armed crime. Kathy Hochul, the governor of New York, said that this decision isn't just careless, it's reprehensible. Eric Adams, mayor of New York City, stated that this decision has made every single one of us less safe from armed crime. After their application for permits to carry concealed handarms for personal protection were denied, the New York State Rifle and Arm Association and 2 of its members, Robert Nash and Brandon Koch, filed a lawsuit.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
Getting weapons, AR-15s, out of the hands of people who shouldn't have them.
There should be an assault weapons ban. I think it would have been up to the Ohio legislature.
Richard McNally of the New York Supreme Court determined that neither man had adequately demonstrated the need for self-defense to permit open carry of an arm. The plaintiffs subsequently appealed that decision before a federal court in New York. A federal judge in New York rejected the case, and the U.S. Second Circuit Judge of Appeals upheld the ruling. The matter was then chosen to be heard by the U.S. Supreme Court. The proper cause requirement, as it has been interpreted by state courts in New York, according to Thomas's majority ruling, is in contrast with the history of arm regulation in the nation. Justice Stephen Breyer, however, asserts that the court can only draw the inference that New York's arm control laws are not compatible with the nation's historical history of arm control by ignoring the vast body of evidence that supports such regulations. The standards that lower courts used to decide whether arm control laws were constitutional were altered by Justice Clarence Thomas's Bruin decision. The conservative majority maintains that such restrictions must take into account the nation's historical context. Rahimi was charged with a crime that was prohibited in Louisiana, Texas, and Mississippi as a result of the 5th U.S. Circuit Court of Appeals decision to reverse its initial ruling in Rahimi's case and agree with the Supreme Court's judgment. Rahimi had asked the Supreme Court to keep out of his case, arguing that it would be premature for the justices to get involved while lower courts were still getting used to the new legal standard established by the Bruin decision.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
The NDB, you've lost thousands of weapons at the NDB prior to your time, I like to add.
Many important cases are still awaiting rulings from the Supreme Court as lower courts reconsider arm bans that had previously been upheld under intermediate scrutiny and deference to legislative discretion. The Justice Department chose to expedite the process, claiming that the measure was both constitutional and essential for reducing crime. They argued that Section 922G8 is consistent with historical examples where the government has taken away the weapons of those who pose a danger to the safety of others. The department claimed that the Fifth Circuit's contrary conclusion violated rulings by earlier appellate courts, improperly applied Supreme Court principles, and presented grave risks to victims of domestic crime. This upcoming Supreme Court review is poised to have a big impact on the intersection of domestic crime restraining orders,
an escalation in violence perpetrated with guns, particularly among our young people, in a manner that I have never seen before.
Criminals will always find guns. Absolutely. And it is the cities with the most restrictive gun policies in the country where...
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
And Second Amendment rights, perhaps having an impact on armed control laws across the nation. The new legal criteria Justice Clarence Thomas outlined in his majority opinion has changed the legal basis for armed legislation and raised questions about the effectiveness of armed control laws. Judges are entrusted with determining whether the laws are consistent with the nation's historical tradition of arm regulation. The government must prove that the policy is consistent with the lengthy history of arm limitations in the country, according to the Supreme Court's new guidelines for deciding whether arm restrictions are legally permissible. A few days after the Supreme Court's ruling on the Second Amendment, New York passed new legislation that stipulates that anyone applying for concealed carry permits must be of good moral character and prohibits the use of arms in some sensitive areas.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
That men and women in this country have the right to defend their own lives.
A section of the act was contested by 6 arm owners in New York and the New York State Rifle and Arm Association on the grounds that it was illegal. New Jersey law prohibits the carrying of an arm in some places, including public libraries, museums, taverns, and restaurants, as well as on private land, similar to New York's limitations. The enforcement of the sensitive place regulations was halted last month by a federal district court judge in response to legal objections made by arm owners and 4 arm organizations. The Supreme Court's new legal standard threatens federal acts that were passed before the ruling, even though the legal battles in New Jersey and New York have involved new legislation that was approved in reaction to the court's ruling. New Mexico's governor's temporary ban on open and concealed carry is surrounded by controversy. The Supreme Court's Bruin decision has raised legal questions and uncertainty regarding the threshold for arm rights. In May, U.S. District Judge Joseph Goodwin dismissed the case against a West Virginia man who was charged with illegally carrying an arm with an erased serial number after concluding that the law was unconstitutional. A 3-judge panel of the U.S. Court of Appeals for the Fifth Circuit ruled that a 30-year-old federal regulation prohibiting anybody under a domestic crime restraining order from carrying weapons is unconstitutional.
They were and shot by someone and couldn't defend themselves because their guns were taken from them.
Ban them again. Do it now. Enough. Do something.
Justice Department representatives plan to appeal the decision, which could result in a new hearing before the whole Fifth Circuit or a request for the Supreme Court to consider the case. Instances of so-called red flag laws, which enjoy bipartisan support, may open the door for legal challenges to those restrictions. Now, it is acknowledged that restrictions like the Domestic Abuse Arms Act are valid and even essential. According to Esther Sanchez Gomez, litigation director for the Giffords Law Center, applying the Bruin ruling of the Supreme Court has been difficult, particularly when determining whether a weapon regulation is consistent with the historical history of the country. She believes that district courts have had difficulty using the new so-called historical tradition test because they lack the intellectual and methodological expertise that historians have. Since many legal procedures regarding new state arm bans are still in the early stages,
it wasn't a fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
Directly attack the issue at hand, and for me, it's very laser focused. It's violent crime in the metro.
And I will keep doing everything that's based in science and fact and public safety effort.
Judges have been requested to halt the enforcement of the law while the cases are being heard. State and federal efforts to pass stronger arm laws are troublesome because the Supreme Court's new legal standard is challenging to apply, and because recent decisions rejecting both new and old laws. Those who favor stricter arm control laws claim that politicians shouldn't be deterred by the likelihood of legal disputes. The governor of New Mexico, Michelle Lujan Grisham, signed a historic executive order temporarily banning residents of Albuquerque and its surrounding suburbs from carrying arms in public after a string of arm-related fatalities, including the slaying of an 11-year-old boy.
That suspension does not apply to any private property. We have the third highest gun-related injuries in the country, 90% higher.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
If you are committing a crime in Bernalillo County and we catch you, we're going to force you to get treatment through the criminal justice system.
For 30 days, open and concealed carry in New Mexico will be prohibited, with the exception of security guards and law enforcement officers. This was a public health order that was immediately implemented. The highest possible fine for violations is $5,000. New Mexico is one of 38 states that don't require a permit for open carry. The only 5 states, California, Florida, Illinois, New Jersey, and New York, that forbid open carry also allow it with a permit include Connecticut, Hawaii, Maryland, Massachusetts, Minnesota, Rhode Island, and South Carolina. Intense controversy and criticism have followed the recent decision by Governor Grisham to temporarily ban open and concealed carry of weapons in Bernalillo County and Albuquerque.
Living in Albuquerque and Bernalillo County, I believe that you're safer for the next 30 days.
That men and women in this country have the right to defend their own lives.
Critics claim that the measure sets a concerning precedent and infringes on the Second Amendment rights of local inhabitants. Arm rights activists claim that the ban, which was enacted during a public health emergency, is a questionable use of governmental power and could pave the way for future limitations on individual liberties. Due to the restriction, some law enforcement authorities have chosen not to participate in its implementation because they believe it breaches the citizens' basic constitutional rights. Critics of the governor's actions are urging law enforcement agencies and personnel to consider the historical context and implications of the restriction. According to them, it is critical for law enforcement to be aware of the possible consequences of supporting such restrictions on the right to bear arms.
This problem is real, and I'm grateful to be part of the solution, and I'm grateful for our governor's work in bringing together.
We're outmanned, we're outstaffed. We do need responsible gun legislation.
Or licensed security officer shall possess a firearm.
The Supreme Court rejects the appeal of a contentious case. The Supreme Court recently declined to review KCI versus the F Judicial District Court of the state of Nevada, a fascinating farms case. A producer of arm mags was sued in this instance because a felon had utilized one of their mags. The victim's family then filed a lawsuit against KCI to try to hold them accountable for the careless creation of a product that was afterwards used in a crime.
On August 4, 2019, an individual criminally misused one of the KCI magazines to essentially perpetrate an unlawful shooting.
Healing Plaka to hold gun makers accountable for their products and the marketing of those products could improve gun safety in America.
But then the family of the victims filed a lawsuit against KCI based on their allegation.
I want to say you may think that Congress does nothing about guns.
Was sued because one of their magazines was used by a criminal. The family of the victim then sued KCI.
The PLCAA is the key issue at hand. Due to its import and distribution of mags to wholesalers for semi-auto weapons, KCI practically only makes standard capacity mags. On August 4, 2019, someone committed a felony by illegally using one of KCI's mags to carry out what amounted to an illegal slaying. The relatives of the victims then filed a lawsuit against KCI, claiming that the company's careless production of mags was to blame for the slaying. After that, KCI filed a motion to dismiss the complaint, arguing that because its mag is a component part of an arm, it is entitled to protection and immunity under the Protection of Lawful Commerce and Arms Act.
But the one thing it did was to pass PLCA.
Many Parkland families strongly believe that gun companies must also be held responsible for the dangerous marketing of assault weapons.
So the Supreme Court has denied review of a case which involves whether firearms magazines are actually firearms parts.
And I was inspired to introduce the repeal of PLCA because the Newtown families went to court.
The 8th Judicial District in Clark County, Nevada, handled this issue at first, and the court determined upon review that KCI's mag was not a component portion of a firearm qualified for protection under the PLCAA. As a result, the court declined KCI's request to have the lawsuit dismissed. In response, KCI filed a writ of mandamus with the Nevada Supreme Court, claiming that the lower court had made a clear mistake by dismissing the petition to dismiss because the firearms mags were, in their opinion, clearly a component part of an arm that was entitled to protections under the PLCAA.
This magazine is a component part of a firearm and therefore entitled to the protection and immunity under the Protection of Lawful Commerce and Arms Act.
The law provides broad immunity against civil lawsuits unique to the gun industry,
in an attempt to hold them liable for the negligent manufacture of a product that was then used in a crime.
Bill to repeal the PLCAA, PLCA, the Protection of Lawful Commerce and Arms Act.
Protected by the PLCAA, and whether or not companies that make and sell these magazines can be sued and be held liable.
On reversal, the Nevada Supreme Court rejected KCI's petition as well as the writ of mandamus. As a result, KCI and this corporation have petitioned the Supreme Court for intervention by responding to a writ of certiorari issued by the Supreme Court. Simply put, the Supreme Court was asked to decide whether a mag falls under the Protection of Lawful Commerce and Arms Act's definition of an arm component part. You might now be wondering what the PLCAA, or Protection of Lawful Commerce and Arms Act, actually is. A U.S. legislation known as the PLCAA protects arms dealers and manufacturers from legal action when criminal acts are performed with their goods. In situations when a third party steals an arm and uses it to commit a crime, it is intended to avoid lawsuits against arm makers or dealers.
Placed an injunction against California's enforcement of what they consider to be so-called high-capacity magazines.
Gives private citizens the right to possess a firearm, including a pistol.
They say that when we argue for removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
To the newsroom, California cannot ban gun owners from having detachable magazines that hold more than 10 rounds.
Any legal action brought by someone looking for monetary compensation from a trade group, a manufacturer, or a retailer of a qualified goods, as well as punitive harm and either declaratory or injunctive relief. How to interpret the PLCAA. Because of their criminal or illegal use of a qualified product, an individual or third party is not entitled to any abatement, restitution, fines or penalties, or other remedy, according to the PLCAA. According to the PLCAA, an eligible product is any weapon, including any antique weapons, component parts for weapons, or ammunition that has been transported or delivered in domestic or international trade. This indicates that the PLCAA is meant to cover not only weapons, but also ammo and parts. In this case, however, the judge determined that the complaint should not be dismissed in accordance with the PLCAA, because in their opinion, an arm mag is not a component portion that provided protections for this kind of claim.
Many Parkland families strongly believe that gun companies must also be held responsible for the dangerous marketing of weapons.
To provide the most basic, common sense, sensible measures.
Fortunately, the Department of Justice has a long history of intervening in civil cases filed by gun violence survivors to defend this law.
But our obligation in the Justice Department is to defend the constitutionality of statutes.
The lower court cited two key arguments for not classifying a rifle mag as a component element under the PLCAA as follows. They said that since the rifle could still fire one shot without a mag, they came to the conclusion that the mag was not a necessary part for the weapon to function. Additionally, they emphasized that a mag was not necessarily bought or sold along with the particular arm that was used in the crime. They argued that the PLCAA did not apply in this situation as a result. In his petition, KCI properly cited a prior ruling from the District of Nevada Prescott, which held that a bump stock should be regarded as a component portion of an arm under the PLCAA.
Here's the amount of gun violence that has happened. I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
They tried to apply the laws that are imposed on every other industry.
Peeling Plaka to hold gun makers accountable for their products and the marketing of those products could improve gun safety in America.
Legalize suing gun companies out of existence with frivolous lawsuits.
A bump stock was deemed to be a component portion of an arm in that case because the court determined that the term component implied an essential constituent part. This is because rifle stocks, which include bump stocks, are necessary for a rifle to shoot in order for it to function. So without rifle stocks, a rifle won't fire. By pointing out that, in this particular case, a bump stock is considered to be a component part and is thus protected by the PLCAA, but a mag in an AR-15 is not considered to be a component part and is therefore not covered by the law, KCI called attention to the inconsistency in the court's reasoning. This inconsistency arises from the assertion that it is not necessary to have a mag in order to fire a single bullet, according to the justification provided by the lower court.
Safe storage would make it unlawful for me to have the 22 and the 20 gauge propped up by my door right now.
There was a lot of concern about public safety implications here. Kira, all of the justices across the bench were worried.
Nothing's going to change for the foreseeable future. And when I say that, I mean for years.
Would prohibit a law-abiding citizen from giving a gun to a friend as a gift.
One could counter this claim by pointing out that while a bump stock and a stock are both necessary for operation, the logic used by the lower court suggests that a mag isn't one of those components, which could jeopardize the PLCAA's legal protection for it. This is one approach to argue against it. Effects on accessory makers and potential lawsuits. It is crucial to remember that the argument over what, in the PLCAA's eyes, constitutes a component part raises concerns about the potential vulnerability of accessory producers when thinking about the effects of the current KCI case. If it is decided that a certain accessory is not necessary for an arm's basic functionality, it may be feasible to omit it from the protections offered by the PLCAA. Examples of such devices include optics, iron sights, arm grips, forward vertical grips, slings, and others. According to this school of thinking, victims seeking legal redress might sue accessory makers if a third-party criminal committed a crime during an arm that was fitted with such attachments.
Or just someone just saying, I need it for my own self-defense. Is that a sacrosanct right?
Your right to own a gun can also be restricted.
Why is this industry given that special exemption? Why is it given a special break?
There are worries that the PLCAA would have a problem as a result of this decision, making the law less effective in its goal of protecting companies that provide arm attachments from the potential of being held liable. In this scenario, it is suggested that if the PLCAA does not include accessory-related lawsuits, it may in the future encourage more people to file lawsuits against accessory manufacturers. KCI and other businesses with a similar business model contend that the Supreme Court should intervene in this matter, even though it is in a middle stage in the judicial process.
That has now then led to the KCI and this company filing a writ of certiorari of the Supreme Court and asking for the Supreme Court to step in.
The laws of negligence, of liability for defective product,
held the Protecting Lawful Commerce in Arms Act unconstitutional.
And they face a defense that says, we are different. The law doesn't apply to us.
According to them, the PLCAA and the dismissal request should have been granted, which would have effectively prevented the matter from moving further in accordance with the PLCAA's rules. Having stated that, it is crucial to draw your attention to the Supreme Court's recent decision to refuse to review the KCI case. This suggests that the case will proceed in lower courts where it will ultimately be resolved according to the merits of the argument. This new information will be crucial for potential legal battles involving the PLCAA. Anti-arm organizations have increased their litigation practices in an effort to discredit the protections offered by the PLCAA and pursue negligence claims. The Supreme Court's decision not to review the case may increase the likelihood that similar lawsuits will be brought in the future. The idea that the country's top court is reluctant to become involved in disputes of this sort may be the cause of this.
Unfortunately, the Protection of Lawful Commerce in Arms Act, known as PLACA,
Major Second Amendment case is before the Supreme Court today.
This is the foundation of liberty.
As a result, there is a higher likelihood that there will be an increase in the number of lawsuits that target manufacturers of arms and accessories in the upcoming years. This will bring up important legal and policy issues about responsibility in situations involving weapons and related products. Supreme Court denies challenge to New York's concealed carry legislation and ammunition limits. A case that challenged the recently enacted concealed carry legislation in New York and the ammunition limits that it imposes was recently turned down by a Supreme Court. Gazzola v. Hack is the name of the case, and it was brought before the court by the Concealed Carry Instructor Association. The emergency application that was sent to the Supreme Court in an effort to challenge the new ammunition limitations that were put into effect in September was at the center of this case. These prohibitions were included in New York's criminal code, which was imposed in open defiance of a recent judgment made by the Supreme Court.
Do Americans have a fundamental right to carry handguns in public in the name of self-defense?
This was a hugely consequential Supreme Court case today, both for public safety and for gun rights.
Contrast this with the tyrannical governments of Europe who are, quote, afraid to trust the people with arms.
Well, the case challenges a New York law requirement for people to get that license. Gun rights groups say they're too strict.
In the case New York State Rifle and Arm Association versus Bruin. The Gazzola lawsuit largely concentrated on how the CCIA affects arms dealers and retail arms stores, specifically the new background check system for ammunition that the CCIA implements. These firms contended that the CCIA is illegal because it violates both the Second Amendment and the Supreme Court's recent judgment in Bruin. Bruin was the case in which the Supreme Court ruled that a ban on assault weapons was unlawful. They argue that they are indispensable to the right to keep and bear arms, and that the CCIA intends to do away with them in order to impose restrictions on the purchase of ammunition that are in violation of the Constitution.
Over this case on Second Amendment rights, the biggest one in a decade.
Why do we have guns? Why do we have the Second Amendment? Is it to hunt?
Discretionary. It gives state officials the ability to limit someone's constitutional right.
Self-defense? That's even more important.
The most recent ruling handed down by the Supreme Court in the case of Bruin, which invalidated New York's May-issue concealed carry licensing program on the grounds that it was incompatible with the nation's history and tradition, served as the impetus for this legal action. One of the most important takeaways from the Bruin decision was that the government must provide evidence that the restrictions it imposes are consistent with the nation's history and tradition.
New York state law that puts limits on how a person can receive a permit to carry a handgun concealed.
Tyrants disarm the people they intend to oppress. Those are the facts.
Preventing New York from becoming the next Sandy Hook, the next Parkland, the next Orlando, the next Las Vegas, the next community devastated by gun violence.
The right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic.
In spite of this verdict, the state of New York continued to enforce its May-issue CCW license scheme, and it even made the scheme more restrictive than the one that existed previous to Bruin by instituting new restrictions like the ammunition background check system. This was done in order to comply with the ruling that was handed down in Bruin versus New York. In the beginning, the plaintiffs approached a district court with their request for a preliminary injunction and a temporary restraining order. Both pleas, however, were promptly turned down by the district court. As a means of responding, the plaintiffs lodged an interlocutory appeal with the Second Circuit, asking the court to rule on whether or not the denial issued by the district court was an error. The appeal was initially turned down by a panel of 3 judges from the Second Circuit. They stated that the lower court had fully evaluated the relevant factors, and that the earlier decision to turn down the appeal was appropriate. In response to the first denial of their claim, the plaintiffs filed a petition with the Supreme Court, requesting that they be granted a writ of certiorari before judgment.
Mr. Chairman, we are not telling them to repeal the Second Amendment. We are telling them to read the Second Amendment.
That's not a right of government. That's a right that each of us has as Americans.
Assault weapons' only purpose is to kill people efficiently.
And now ammunition. It's part of the Concealed Carry Improvement Act that Governor Kathy Hochul passed last year.
This was an intriguing approach to get the Supreme Court to review the matter sooner rather than later. Supreme Court denies a request for early review of ammunition background check case. A petition of this kind asks the Supreme Court to review a case before a lower court makes its final decision on the merits of any verdict. This is done before the lower court reaches its decision, so the Supreme Court can use its statutory right to do so. In the end, the request for review before judgment was denied by the Supreme Court, and the court stated that it would wait for the ruling on the appeal from the Second Circuit before interfering. This decision wasn't all that surprising, given that the Supreme Court has previously turned down requests that were very similar to this one.
What they did in determining that appeal for a stay was even the correct process.
They are coming for your guns. They're listing them out in this extensive legislation.
The Soviets instituted gun control and millions were killed. 20 million dissidents were rounded up and exterminated.
It could have huge implications for the number of guns on the street.
Cases such as the Antoinette case were presented as emergency applications to Justice Alito and some of the other justices. But emergency review was not granted in these cases. However, Justice Alito did note that they were interested in the issue, and they did warn the Second Circuit that they needed to accelerate the consideration of these cases, or at the very least, provide some rationale for why they denied the preliminary injunctions, or have an expedited hearing. This warning was given after Justice Alito mentioned that they were interested in the case. In the event that they did not, it is possible that the Supreme Court will take a look at the matter. The 5 CCI cases, including the Gazzola case, were argued before the Second Circuit on an expedited basis back in March. However, the Second Circuit has not rendered a judgment since that time. In the meantime, the state of New York carried out the implementation of the background check system for ammunition on September 13th, when it became operational. Due to the fact that this new ammunition restriction was implemented, as well as the inactivity of the Second Circuit, the plaintiffs in the Gazzola case approached the Supreme Court on an emergency basis once more in an effort to seek a stay of the ammunition background check system until the Second Circuit issued its decision.
The Supreme Court announced today that it will hear a major gun control case out of New York.
This case is basically, does New York and other similar cities and states.
These were successful in the first instance, enable the people to resist and triumph over them.
Gun safety laws, gun licensing laws save lives, plain and simple.
At the very least, while the appeals process was still underway, the plaintiffs in the lawsuit urged that the Supreme Court put a halt to the execution of the background check requirement that applies to ammunition. One of the primary grounds for this request was the delay in the decision that was handed down by the Second Circuit, as well as the effect that this decision had on the background check system for ammunition that was put into place and went into force on September 13th.
Once again, we are nearly 2 weeks into new state regulations when it comes to buying ammunition.
Well, I would say greater than 75% of our customers have been delayed.
Yeah, so we wanted to follow up on how things are going for gun shop owners and their customers.
I don't know how a federal law enforcement officer that's currently working needs to go under additional review.
You're making it difficult. I'm not the person you have to worry about. It's the bad guy you got to worry about.
The initial request for review of the emergency application was submitted to Justice Sotomayor, who is in charge of reviewing emergency requests coming from the Second Circuit. The very next day, however, Justice Sotomayor issued a ruling that rejected the application. As a result, the plaintiffs in the Gazzola case had to refile their motion and send it back to Justice Thomas. They are free to pursue any kind of justice after an application has been rejected, but there are some procedural regulations that govern who must first assess the case. Therefore, Justice Thomas was selected. Following that, the matter was sent up to the Supreme Court for a discussion that will take place on October 6th. The conference is the time when the court deliberates on whether or not to reconsider a case that has been brought before it.
The justice is hearing arguments for just about 2 hours, an hour over the scheduled argument time, Kira.
This will not do any good. It will harm Americans, and it undermines our foundational liberties.
If this is rolled back, it could have sweeping complications nationwide, implications.
Being able to defend their public spaces and protect their citizens from gun violence.
The ruling that resulted from that conference was issued not too long ago, and the Supreme Court ultimately opted against reviewing the Gazzola case. This indicates that for the time being, the Supreme Court will not act on an emergency basis to block the current system for conducting background checks on ammunition purchases. This may have an impact on the ability of many persons living in New York to purchase ammunition.
Firearm background checks will be processed by the New York State Police first before going through the FBI.
Evening, a new law went into effect today, changing the way the state handles background checks for firearms.
It also requires a state background check for all ammunition sales.
But in order to sell a lie to the American people, that the government will protect them from all manners of evil.
Because the Second Circuit has already heard of all these CCI cases, including Gazzola, and the decision is still pending, it was always improbable that the Supreme Court would intervene in this case, particularly in its current posture. This is because the Second Circuit has previously heard all of the CCI cases, including Gazzola, and the decision is still pending. Supreme Court's decision notably without dissent. It's also telling in some ways that there was no dissent on this denial, which means that none of the judges felt strongly enough against the denial to write something about why they had denied it. The Supreme Court has generally taken the position that they're not going to step in on these Second Amendment issues, especially at an early stage. Instead, they're going to give the lower courts the opportunity to decide these issues before stepping in. It was also noted that the recent emergency applications for relief that went to the Supreme Court involving the ATF did not go in favor of the Second Amendment.
Gun confiscations facilitated by laws requiring the registration and licensing of firearms.
There's this argument that it's going to be the Wild West if we, allow anybody who wants to carry a firearm.
This is why the Second Amendment matters. It's not trivial. It's not something you just brush aside.
Experts say it could result in more firearms, concealed firearms, on the streets of many major cities. Kira?
This body are willing to take away a citizen's God-given right, yes, God-given right, that was mocked earlier.
Recently, the ATF went to the Supreme Court and asked them to stay the vacator of the frames and receivers rule, and in that case, Justices Roberts and Barrett joined the liberal justices to grant the stay in favor of the ATF. Even more recently, Justice Alito put in place an administrative stay. In our opinion, we don't think it's super telling that Justice Alito put that administrative stay on Vanderstock. We will have to see how the full court decides. Remember, Justice Alito was against the original stay that was put in place. The stay on the Vard, Alito and Gorsuch, and Thomas wrote against it. So, we don't think that's super telling that at least Alito put the administrative stay right now in Vanderstock. We will see how that plays out. However, it's telling that the Supreme Court, at least right now, seems to be hands-off on these Second Amendment cases and is simply probably going to wait until they issue a decision in the upcoming decision, which is going to be the Rahimi case.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights,
to defend themselves, and if the Supreme Court strikes down this law, Kira,
and importantly from the very tyranny being applied to them to deny that right.
Jurisdictions should have the ability to decide who can and can't get these weapons.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
But right now, at least in Gazzola, they're hands off, and they're letting the Second Circuit make their way through the process. Unfortunately, this is one of those situations where a lot of New Yorkers were hoping that the Supreme Court would step in early and grant some sort of relief. But the Supreme Court is staying true to their process, and they're going to wait for the lower court to resolve the case before they step in. They did this earlier in the Anono emergency application, and they also did this earlier in the Gazzola case, and they're just simply doing it once again. So that's what's recently happened with the Gazzola emergency application that went up to the Supreme Court, that a lot of people in New York were waiting for. The Supreme Court has denied review in this case and appears to be opting to once again let the lower court resolve the case.
To protect himself or herself or her family or his family from harm.
They are obsessed with attacking law-abiding Americans' Second Amendment liberties.
Do you expect that this will go all the way to the Supreme Court?
Yeah. That you cannot justly take away from a free and equal human being.
Now we will continue to wait for the Second Circuit and wait for them to issue their decisions. But again, they've been sitting on the decisions for a long time and they have not issued them. That's all for this video, folks. See you next time.